Welcome to St. Thomas Law. It's wonderful to see almost 150 of you here today, including nearly 90 mentors, alumni, and friends, along with so many of our students. This turnout speaks volumes about the reach and influence of our mentor externship program and to Judy Rush's care, vision, and deep belief in mentoring the next generation of lawyers and judges. For more than 12 years under Judy's leadership, mentor externship became a cornerstone of the St. Thomas Law experience, connecting students with mentors who model professional excellence, integrity, and purpose. The thousands of mentoring relationships Judy helped create and the hundreds of lawyers she personally mentored continue to shape our students, our alumni, and our profession. We are deeply grateful to the Senior Lawyers and Judges section of the Minnesota State Bar Association, a section that honors and supports senior lawyers and members of the bench, and champions mentorship for recognizing Judy's remarkable contributions with the 2025 Mentoring Award. Because this celebration is also for you, our mentors, we're pleased to follow the award with a complimentary CLE by Professor Michael Paulsen as a small token of gratitude for your generosity, your time, and your belief in mentoring. And now to present the 2025 Mentoring Award, please join me in welcoming Marlene Garvis, Chair of the Senior Lawyers and Judges section of the MSBA, and Karen Grossman, a member of the Senior Lawyers and Judges section of the MSBA.
Should Judy be up here?
No, she's coming.
Okay. I'm just so honored to be here. There are so many wonderful mentors, and it's just a privilege to honor them. I was on the selection committee, and I did tell Judy this when we were in line, but I wanted everybody to know I was privileged to be able to read lots and lots of really good testimonies about the mentors, and every one of us on our committee independently chose Judy before we gathered together. So this is very well deserved.
Thank you, Karen. I just want to say a few words. The MSBA Senior Lawyers and Judges section initiated the section's Mentorship Award in 2024. The goal is to recognize an attorney who exemplifies mentoring, and the qualities that the award committee considers includes accessibility, emotional intelligence, empathy, expertise, experience, ability to listen without judgment, patience, proactive engagement, trustworthiness, unimpeachable ethics, and responsiveness. Judy Rush embodies all these qualities the award honors and has dedicated her career to guiding and shaping generation of lawyers into caring and ethical legal professionals. As background, as it's already been stated by Yunan, in addition to her law practice, Judy Rush taught professional responsibility at Hamline University School of Law for 15 years and legal advocacy to students to develop their written and oral skills. From 2006 to 2011, she served as a mentor in the law school mentorship externship program. And from 2011 to 2022, she served as the director of the program at the University of St. Thomas Law School. As a result of her work, the law school mentor and externship program was recognized in 2024 by Bloomberg Law as a top school innovation. In addition to all of that, Judy has been involved in Lawyers Concern for Lawyers for over 20 years, where she continued to extend her mentorship beyond the classroom to Minnesota's legal professionals, including law students, lawyers, and judges. As her colleagues have said, and as you've already heard this morning, or afternoon, influence with her mentees endures, and her commitment to mentoring is unmatched. It cannot be said better than this, in quotes, Judy Rush is the kind of mentor every student and lawyer hopes to find. and which every profession needs more of. As chair of the Minnesota State Bar Association Senior Lawyers and Judges Section, I ask you to help me congratulate Judy Rush, the 2025 winner of the State Bar's Lawyers and Judges Section Mentoring Award. Please come up, Judy.
Thank you so much, Marlene. And congratulations again, Judy. You are truly deserving of the 2025 Mentoring Award and my Obi-Wan always. As we continue this celebration, we also want to express our gratitude to you, our mentors, with today's CLE program. Just a note that some of our students will have to leave early for class, but the CLE will continue to 1:45 p.m. We are honored to welcome Professor Michael Stokes Paulsen, Distinguished Chair and Professor of Law here at St. Thomas. Professor Paulsen is one of the nation's leading constitutional scholars and a prolific writer whose work explores the limits and design of presidential power, the separation of powers, and the moral dimensions of constitutional interpretation. This afternoon, he'll offer a timely and thought-provoking presentation titled Constitutional Crises of the Trump Presidency. It's a big picture overview of the extraordinary constitutional questions raised by the actions of the current administration. Issues that go to the heart of our system of checks and balances, the rules of law, and the responsibilities of lawyers in a democracy. Please join me in welcoming Professor Michael Stokes Paulsen.
Well, thank you for that warm introduction, almost perjurious introduction, and the warm welcome. I'm glad that you've been offered, as a token of our gratitude, that you get to attend a CLE. Most of my students regard it as a token of punishment when they have to listen to me talk. My title is The Constitutional Crises, in the plural, of the Trump presidency, and it's loosely based on the title of a new law school course that I began offering this year, just sort of as a pop-up course dictated by the unique circumstances in which we find ourselves. That's one I've titled Constitutional Crises of the Current Regime. What I'm going to do today is basically, since we have like only an hour, and I have about 15 hours worth of material, I'm going to try to walk you through the syllabus, actually a syllabus overview, which has been provided. It shows up on the second page of the handout there, and just sort of talk through, general terms, a bunch of the issues that have been facing the nation since the return to the presidency of Donald Trump. Each of the topics, this is basically the outline of a 13-week, 2-hour class that meets Wednesday afternoons. And each of these topics really could be a seminar or a full-blown course in its own right. So I'll talk for about 5 minutes each about 13 different topics, and for each of the topic, there are about 10 subtopics, so I should be here for about 6 hours. You are free to leave, and I will eventually stop talking. I'm often asked the question this way: is America in a constitutional crisis? And I think the fair answer is absolutely it is. And that's part of the reason for this course, is the sense that what is going on now is not in any sense normal. This is not constitutional law or constitutional politics as usual. What is going on in the nation today is really an unprecedented crisis a self-inflicted crisis, and perhaps an existential crisis concerning the American Constitution and whether it will continue to operate as a rule of law constraining our government. When I told the students when I offered this course, I said that this was going to be something that was very unique of them to do. We will be inventing the class material as we went along. And I've been barely 1 week ahead of the students in preparing assignments and assigned materials. I call it constitutional crises, plural, because it consists of numerous separate constitutional crises, right? And the overall constitutional crisis is kind of created as part of the whole of the crisis is actually larger than the sum of its parts. And so you don't have a sense of missing the forest for the trees. Let me just talk about what I see the overall broad crisis to be. And that is the potential devolution of the US constitutional system into a system of functional presidential supremacy and tyranny headed by an executive who is perhaps not lawfully entitled to be president of the United States, and whose actions are in myriad respects in violation of the Constitution of the United States, and who seems prepared to act in open defiance of the Constitution of the United States. The three large themes that kind of unite many of these actions are, first of all, the attempted centralization and concentration of power. The accumulation of all power, legislative, executive, and judicial, James Madison wrote in the Federalist 47, in the same hands, whether of one, a few, or many, and whether hereditary, self-appointed, or elective, may justly be pronounced the very definition of tyranny. The accumulation of all powers in the same hands, whether legislative, executive, or judiciary, whether in if one, a few, or many may justly be pronounced the very definition of tyranny. Mr. Trump has attempted, and this unifies several of his discrete actions, to concentrate and augment and unify all federal government power in the presidency, and specifically in himself as an individual, right? To circumvent the usual executive branch restrictions on executive power. The second feature of the overall pattern of Trump's activities during these first 9 months of his presidency has been the attempt to eliminate, eviscerate, or evade the checks and balances of the other branches of government. At the same time that he's centralizing power in the person of the president, he is seeking to thwart the power of courts to restrain him and rein him in, and to co-opt the powers of Congress in support of his positions. And then the third unifying feature of many of these particular issues is the attempted suppression of dissent and opposition, efforts to punish, prohibit, or penalize the expression of views of dissent, and to retaliate against and target political enemies and opponents in the government, in the military, in universities, in law firms, and in private businesses. So with those three themes in mind, let me just walk through the syllabus and give you an introduction to this course. Class session number 1 was devoted to the constitutional framework that we'll be operating under. Different professors have different approaches to constitutional law, and I wanted to expose students to my own views and to get them to think about constitutional issues in a way that they perhaps had not thought about them before. So that first class session is addressing questions of what are the premises, what is the design, and what is the political theory of the Constitution, as explained in the Constitution itself, and is explained very aptly in the Federalist Papers of Alexander Hamilton and James Madison. And one of those core features is the separation of powers and checks and balances resulting from the separation of powers into independent branches, none of whom is bound by the actions and interpretations of the others. Another thing that I attempted to introduce in this first class session is the question of how is the Constitution to be interpreted, right? How does one go about the task of faithfully interpreting and faithfully applying the Constitution? How does one go about the enterprise of constitutional interpretation? And I posed to the students during that first class session 3 questions and a big hypothetical. The hypothetical will be a sort of a fun problem. The first question is the Constitution law or not? If the Constitution is law, what makes it law? And what does it mean when we say the Constitution is supreme law of the land? So that's the first big question, is the Constitution law, and what sort of law is it? The second big question I asked is, does the Constitution matter? Does law matter, or is the only thing that is relevant power? Does law matter, or is power all that matters? And then the third introductory question was, is our Constitution sufficiently well designed to guard against tyranny? Right? This is something that James Madison and Alexander Hamilton defend in the Federalist, that the Constitution, its separation of powers and its allocation of powers is designed to empower the federal government sufficiently to meet the needs of a nation, but at the same time constrain that power with the checks and balances of this arrangement of 3 divided branches of government. So with those 3 questions, one of my desired lessons for the students is to understand that ours is a written Constitution, not an unwritten Constitution. And that seems obvious enough, but our constitutional system is one of adherence to an authoritative, binding, written text, a document, right? The document small enough you can keep it in your coat pocket. It is a binding authoritative text in the sense that it is theoretically the text that provides the answers to the legal questions of constitutional law. The enterprise of constitutional interpretation I try to instill in the students is the enterprise of trying to ascertain the meaning of the words of the text. And that is, at least in theory, something that is objective, right? It is not just that everybody can make up whatever meaning they want to the words of the Constitution. The words are written down and they have at some level a determinate meaning. The Constitution is law, and it is supreme law in the sense that it is not superseded by elections. An election cannot overturn the Constitution. We believe in democracy, but it's distinct from parliamentary systems where the parliament that is elected essentially forms the Constitution on an ongoing basis. That's the arrangement in England. Parliamentary supremacy means that the English Constitution is a constitution of evolving principles over time as they are enacted by the Parliament. That is not our system. Our system has the Constitution as a fixed charter, and an election cannot overturn the Constitution. Neither is the Constitution superseded by a presidential edict that contradicts the Constitution. If the Constitution says one thing and the president says another, the Constitution wins. If Congress passes a law that says one thing And the Constitution says something entirely different. The Constitution beats the law enacted by Congress. That's the basic premise of judicial review. The Constitution is also not superseded, and this is a little more controversial and dicey, by decisions of the courts. If the Constitution says one thing, and a decision of the Supreme Court or any other court is saying something else, the Constitution beats the conflicting view established by the judicial decision. In short, conflicting actions by the executive, by the legislature, by the judiciary, actions that conflict with the US Constitution, do not change the meaning of the Constitution. They are violations of the Constitution, and they deserve to be treated as such. So, rather than give this to the students in the form of a lecture, I start off the first class with a hypothetical, or what I hope will be a hypothetical. Trump is elected to a third term. Okay, don't panic, don't lose your lunch. The 22nd Amendment to the Constitution establishes that the president is limited to 2 terms. The president may not serve third terms. Now, put aside all sorts of imaginative arguments about how maybe Trump could become elected vice president and the president resigns and Trump becomes president. I want you to assume for a second that the 22nd Amendment says absolutely clearly that you can't serve a third term. And I think that's exactly right. Here's my hypothetical. Trump nonetheless runs for and is elected to a third term. Now, assume that a challenge had been made to his eligibility and a case had gone up to the US Supreme Court in which it was argued that Trump cannot serve a third term. Imagine that the Supreme Court, in a seemingly inexplicable, obviously wrong, transparently result-oriented decision, either from cowardice or out of craven appeasement of Trump, has held that the 22nd Amendment, notwithstanding what it says, does not prevent Trump from being president. Are you with me on the hypothetical, class? Okay, now, okay. So Trump is unconstitutionally elected, sworn in, and inaugurated. So here's the question I present to my students. Is Trump president for a third term? And actually, if you think about it, that presents all of these issues about whether the Constitution is law and what it means for it to be supreme law. Has the Constitution, under my hypothetical, been superseded or repealed, or has its meaning been changed by the fact of election? And the students, after some hemming and hawing, because they're wondering what the trick is in this question, say, no, the Constitution means what the Constitution means. Let me say that again. The Constitution means what the Constitution means and is not altered by the fact that an election reached a result that is unconstitutional. Nor is the Constitution's meaning changed by the fact that the Supreme Court allowed Trump to be elected. So part of the lessons of this is that constitutional meaning, the meaning of the text of the document, is its own thing. It's something that's theoretically objective and ascertainable. We might disagree as to its interpretation in a particular moment and a particular issue, but it is not something that is purely subjective. If the 22nd Amendment has a determinate meaning, that meaning is the Constitution's meaning, and it is not erased by an election or an action of the President or of the Congress or of the Supreme Court to the contrary. Actions to the contrary are simply violations of the Constitution. The last question that I posed in that first class is the question of whether our Constitution really is well designed. Now, you're always taught in the civics class and in the US history and in Constitution Day lectures about how wonderful the Constitution is. But I think it's interesting to pose the serious question whether our Constitution is sufficiently well designed, as the framers thought it was, to guard against tyranny. And that segues into the second class session, which is all about the failure of checks and balances of a certain sort to have accomplished their end. That second class is entitled Lead Up to Crisis, Defects and Failures of the Constitution's Checks and Balances, kind of a provocative title. And I have the students read a lot of the Federalist Papers, and we review some of the past history of the use of impeachment or attempted use of impeachment as a check, and we discuss whether the criminal law acts as an effective check against presidential misconduct. The founders' views of impeachment were that it was a vital and important and formidable check on executive misconduct. Alexander Hamilton referred to impeachment as a bridle in the hands of the legislative branch upon the executive authority. Sort of picture the idea of a runaway horse and buggy. And the impeachment power is the ultimate check, the bridle on that power. There was unanimous agreement during the framing era that the power of impeachment was extraordinarily broad. The idea that you could remove and impeach and remove a president for high crimes and misdemeanors was not something that had an uncertain meaning. It was a meaning that was traceable to English practice and experience for several hundreds of years. And the term high crimes and misdemeanors had a term of art understanding as permitting removal of presidents for public misconduct, for specific criminal activity, for abuse of power, embracing a wide range of circumstances. And the determination of whether those circumstances applied was for the legislature to make in the impeachment and trial process. It was explicitly a political check on the abuse of constitutional authority. So I asked my students, what is the status of the constitutional check of impeachment? Is it a dead letter? And I raise that question for you too. Is impeachment a dead letter? And we look at the experience of the past really 50 years, and you can kind of mark a trajectory of the decline and seeming demise of impeachment as a meaningful check. When I was a young nerd, as an 8th grader watching Watergate hearings, I was obsessed with what was going on with Richard Nixon. Nixon was subjected to impeachment proceedings, and eventually he resigned rather than face almost certain impeachment and conviction for obstruction of justice and abuse of authority. Nixon resigned in 1974 because he had lost not only the support of the Democrats in Congress, but the support of the Republicans, his own party, who would not stand for presidential corruption. So that's about 50 years ago. 25 years ago, we have the impeachment of President Clinton. And we examine what happened in the impeachment of Clinton, again for crimes, and what ended up radically different in those circumstances was Clinton retained the political support of his own party, notwithstanding evidence of illegality. So 50 years ago, you have Nixon. 25 years ago, you have Clinton. And there appears to be a watering down of the standards of conduct required of presidents, and a strengthening of the idea of partisan loyalties as prevailing over what would otherwise be a legal principle. And at the time, I participated in an academic conference at University of Minnesota where they were discussing the Clinton situation, the Clinton claims of executive privilege and the independent prosecutor. many issues that are in some ways reminiscent of what we had today. And I predicted that a consequence of the Clinton acquittal was that in the future, presidents would not feel bound to adhere to their oaths and to standards of conduct if they could count on the continued support of their own political party. And in many ways, that's come to pass. We look briefly at presidential impeachments of Trump and how he defeated impeachment both times, despite majorities in favor of conviction, because of the near unanimous or unanimous support of members of his own political party. And the question I put to the students is the impeachment power dead? Is it a dead letter? And this is an interesting thing to think about, because if impeachment fails as a check, and if as a president, you know you are not likely to be effectively subject to the impeachment power, it kind of unleashes the president to do whatever he thinks he wishes to do, whether it would be impeachable or not. And I regret that loss of impeachment as a check. I think it can be recovered. I think that power is not lost through its disuse by Congress, but it is an ominous situation that the impeachment power has been rendered a mere toothless scarecrow. The second check that we examine during that second class session is the idea that the criminal law could operate as an effective check on executives, that people would be deterred from engaging in unlawful activities of presidents, not only by the specter of being removed from office, but by the specter of prosecution and criminal punishment. What we have seen in the situations involving Donald Trump between the time he was removed, defeated from office in 2020 and returned to office in 2024, was the ineffectiveness of the criminal law as a check on the president. The criminal law processes were revealed to be slow, ponderous, and ineffective, and provide many occasions for judicial intervention to prevent the operation of the criminal law. The most important of those is a decision of the US Supreme Court in the summer of 2024, just a few months before Trump's election, called Trump versus United States, in which the Supreme Court said that the president is essentially above the criminal law, that the president of the United States possesses absolute immunity permanently from criminal prosecution for anything he does using his presidential powers. Now think about that. The president is absolutely immune from criminal prosecution for anything he does using his constitutional powers. The decision is actually shocking, I think, and extreme. It's almost unbelievable. And if you haven't read it, if you've only read newspaper accounts, I challenge you to read the Supreme Court's decision in Trump versus United States. It literally holds that the president can do anything he wants if it involves use of his constitutional powers. And he is immune from criminal liability, absolutely. So think about the hypotheticals. If the president sells national security secrets to the Russians, if he betrays the country, he cannot be criminally prosecuted under espionage laws. If the president solicits bribes for pardons, he is absolutely immune from criminal prosecution. If a president decides to bomb civilians intentionally using his military authority because it is within the scope of his constitutional powers, he is absolutely immune from criminal liability. If the president invades the nation's cities or orders an assassination of a political rival, or the incarceration of political opponents, he is absolutely immune from criminal prosecution. I find this a little bit monstrous, and it is actually quite lawless. The decision of the court was 6-3 in favor of absolute presidential immunity from criminal prosecution, and the 6 were the so-called conservatives on the court, those who favor generally, or say they do, the approach to constitutional interpretation of adhering to the original meaning of the words of the Constitution. But there is nothing remotely conservative about Trump versus United States. The decision inventing presidential immunity from prosecution, from the criminal law, is nowhere supported by the text of Article 2. Article 2 nowhere provides that the president has any sort of immunity. It is, in fact, it contrasts with Article 1 of the Constitution, which provides specific immunities from arrest for members of Congress when attending sessions of Congress, showing that the framers, where they meant to provide for immunities of some sort, knew how to put it right in the text of the Constitution. The structure of the Constitution is also decisively against presidential immunity from criminal prosecution. The whole idea of checks and balances is that there are intersections and overlaps between the powers of the respective branches that enable one branch to limit what the other branch does. If the president is subject to no such limits, the idea of checks and balances completely goes away. And the decision in Trump versus United States is also demonstrably contrary to the original intent of the framers, who said on many occasions that the president has no immunity, is not above the law, and is subject to the same constraints as everybody else. Further, when discussing the impeachment power, the Constitution says that after impeachment, the president is nevertheless liable and subject to indictment, trial, judgment, and punishment according to law. So the text of the Constitution, the structure of the Constitution, and the history of the evidence of the framers' intentions all decisively reject the idea that the president is not subject to the criminal law. A consequence of the failure of impeachment to operate as a check and the failure of criminal law to operate as a check is that there are very few remaining constraints on what a president can do other than the president's own character. And that is the situation in which we find ourselves. So all of that is just 2 class sessions. How am I doing? I'm not going to finish it. The third class session is address an issue that's near and dear to my heart, and that is the question of, does Section 3 of the 14th Amendment bar Trump from the presidency? Let me read to you Section 3 of the 14th Amendment. The 14th Amendment was one of the constitutional amendments adopted in the aftermath of the Civil War, and it starts by addressing the situation of former office holders who engaged in the Civil War and insurrection against the national government. And it reads as such: "No person shall be a senator or representative in Congress, or elector of president and vice president, or hold any office, civil or military, under the United States or under any state, who, having previously taken an oath as a member of Congress, or as an officer of the United States, or as a member of any state legislature, or as an executive or judicial officer of any state, to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof." That's all one sentence. Roughly translated means, if you held a federal or state office that required you to swear an oath to support the Constitution of the United States, and then engaged in conduct constituting insurrection or rebellion against the United States, think former Confederate officers, you are disabled from holding federal or state office again. The second sentence of Section 3 provides an escape hatch, but Congress may, by a vote of 2/3 of each house, remove such disability. A couple of summers ago, a friend of mine who's a professor at University of Chicago, William Bode, and I wrote an article arguing that Section 3 means what it says, continues to operate as a rule, and disqualifies Trump from being president of the United States for having engaged in attempted insurrection or rebellion in the form of a coup d'etat trying to overthrow the 2020 election. Now, somewhat to the surprise of us as legal academics, this actually got some public attention. The New York Times published it, a story about it. A columnist in New York Times, a man by the name of David French, wrote a column. I was actually sitting at my breakfast table, totally unexpecting this, and getting ready to go to the cabin for the weekend, when the first words out of this column were, "I don't usually recommend to people that they read 140-page law review articles filled with historical citations and hundreds of footnotes, but this is what you should do this Sunday afternoon." And he commends our article, and it eventually gets over 100,000 downloads from the SSRN, Social Sciences Research Network, which was kind of unheard of. We actually crashed the computer system for a time being as people were interested in this theory. People picked up on this theory, and there were numerous court cases, and one trial in Colorado concluded that what Trump had done in the election of 2020 had been insurrection, that he knew that he had lost the election and attempted to overthrow the election results fraudulently and intentionally, and that this constituted insurrection against the United States and that Trump was legally disqualified. The case was appealed to the Supreme Court, as you might expect, and in March of 2024, the Supreme Court said, "Never mind, we don't want to do this." I remember having a conversation with a law professor friend of mine who said, "On what ground do you think you will lose?" And I said, "Why do you think we will lose?" And he couldn't come up with an argument of why our analysis was wrong in any way. But he said, just as a predictive matter, that the Supreme Court was never going to disqualify Trump from the office. And that's indeed what they did in the decision of Trump versus Anderson. The Supreme Court held that states may not, through their election laws, keep Trump off the ballot. States may not enforce Section 3 of the 14th Amendment. Now, there are a couple of interesting things. So we studied this opinion in this class session, and there are kind of some interesting things about what Trump versus Anderson does not say. It does not say that Section 3 doesn't disqualify Trump. It doesn't contest that. It does not hold that Trump didn't participate in conduct constituting an insurrection. It does not say that the Colorado trial courts made findings of fact that were erroneous. They uphold, or at least do not dispute, the findings of fact of the Colorado courts. And it does not actually say that Congress has to pass legislation before Section 3 can be in effect. So they dispute none of our premises, but nonetheless hold that states may not enforce Section 3 of the 14th Amendment. As I was trying to explain this to my wife at the time, it was like a cartoon character who's cornered and has no way out and draws a picture of a window and jumps out the window. And that's kind of what Trump versus Anderson does. So a provocative question I put to my students is Trump still disqualified? Because if the Constitution means what the Constitution means, the Supreme Court's decision that states need not enforce it doesn't mean that Trump isn't disqualified. It just means that states can't enforce it. And we raise and discuss the question, which I haven't seen publicly discussed much since Trump was inaugurated, about whether the idea that Trump is disqualified from the presidency can be employed as a defense against some of the administration's executive orders. The executive is attempting to remove someone from office. Why don't they raise as a defense, not only that you can't remove me, but that you aren't president and you can't lawfully exercise the power of removal? Can you use Trump's disqualification as a defense to criminal prosecution? If you're James Comey or Letitia James and are singled out for prosecution, can you raise, in addition to your other defenses, that I can't be prosecuted by this person who isn't lawfully president? Can it be raised as a defense to deportation proceedings? So I think that this is an interesting and overlooked defense. I have no illusions that the Supreme Court will recognize this as a valid defense. The court that decided Trump versus Anderson was not predisposed to recognize these sort of defenses at all. So in these first several classes, we look at the failure of checks and balances and the failure of the Supreme Court to enforce checks and balances, which kind of paved the way for Trump to be elected. And then in the next several sessions, we have been looking at, and we're about halfway through the course at this time, we've been looking at the constitutional crises specific to the things Trump has done as president in his second administration. And this begins with the fourth class session, which is entitled Consolidating and Concentrating Power in the Executive Branch, Removing Intra-Executive Checks and Appointments Issues. Okay. And what this involves is the activity that I described of Trump attempting to centralize all executive power in the president and to remove from office any executive officers who would stand in his way and oppose him. The first thing he did was fire inspectors general who protected whistleblowers. He fired judge advocate generals who might contest the lawfulness of his military orders. He fired career prosecutors who had worked on the prosecutions of Donald Trump himself. There was a massive wave of firings. Now, I'm reluctant to admit it, but I actually think that as a matter of constitutional interpretation, Trump has this power. The executive power of Article 2 is vested in a president of the United States. And like it or not, I think that means that the president of the United States must control all exercises of the executive power. That means the president must be able to countermand actions of subordinates, direct and control the actions of the administration, and basically exercise the executive power the way he thinks it should be exercised. That doesn't get you quite all the way to a power to remove all subordinate officials, but it is an aspect of the executive power that the president gets to control the administration. And that means that he can fire many executive officers who are not faithfully carrying out his policies as he sees them. There are a couple of cases that are now pending before the US Supreme Court involving this power to fire subordinate executive officials. Trump versus Wilcox was one of these interim decisions on the court's emergency docket, decided in May of this year, holding that Trump could remove from office members of the Federal Trade Commission. The Supreme Court granted cert to decide that issue more permanently, but it seems clear that the Supreme Court is headed toward overruling the precedent called Humphrey's Executor versus United States, which had upheld the independence of members of boards of independent agencies. I think that precedent is not long for that. In doing so, the court, in its interim order, said that it's possible that the Federal Reserve is different, and that's a very important issue. The idea that the Federal Reserve Board could still be preserved as an independent entity flows from the idea that there are certain characteristics of the Fed and of the Fed arrangement that are not making them actually executive officers, but they are quasi-private bankers who have and can exercise some measure of independence from the president. We'll see how that plays out. The upshot of this is that the president can get the executive to do what the president wants the executive branch to do. And that leads into the fifth class session, which was just a couple of weeks ago, which was entitled Executive Orders Without Law. Trump has issued a huge number of executive orders. And the problem is this, simply. Can the president legislate by executive decree? Now, if you remember your first or second week of the constitutional law course, even dating back to the 1950s, you will recall the landmark decision of Youngstown Sheet and Tube versus Sawyer, where the president, President Truman, seized the nation's steel mills to avert a strike. The landmark holding of the Supreme Court, which seems obvious to us today, but wouldn't have been obvious if it had gone the other way, is that the president, by exercising the executive power, cannot legislate. The president cannot legislate. Congress legislates and the executive executes. The president cannot rule by decree. And that is a powerful principle with lots of applications to a lot of things that Trump has done. He has issued innumerable decrees on his own supposed authority that are simply unconstitutional and a clear usurpation of legislative power. He has declared birthright citizenship to not be a situation anymore. He's issued commands about elections, and he's also decided not to enforce laws of Congress. The same principle that says the executive may not legislate yields the further principle that the executive cannot repeal statutes of Congress. If the president cannot repeal statutes of Congress on his own authority, that means that the executive power obliges the president to enforce the acts of Congress. And Trump has notoriously refused to enforce many acts of Congress. TikTok ban, he has refused to enforce. He's refused to enforce the Foreign Corrupt Practices Act, and he has refused to spend money appropriated by Congress. In each of these instances, the president is essentially rewriting or refusing to be bound by the laws, and that's a clear abuse of power. So we spend a lot of time examining that issue. Topic number 6, the abuse or misuse of federal criminal law enforcement power. And this was an interesting class in which I invited a few former federal prosecutors, including Mark Osler of our faculty, who is a long-time U.S. prosecutor in the U.S. Attorney's Office in Detroit and has served as Hennepin County Deputy Prosecutor. Now federal judge Laura Provenzino, who had been a longtime prosecutor in the Minnesota U.S. Attorney's Office, and is more notable for being my next-door neighbor. So I asked her literally on the driveway if she would come talk to the class about her experience as a federal prosecutor. And then the third former federal prosecutor is me. I was, for a time, a lawyer in the criminal division of the U.S. Department of Justice when I just graduated from law school. And I was farmed out to the Eastern District of Virginia, in Alexandria, Virginia, which has been the office that has received some attention lately when the U.S. attorney was refusing to prosecute James Comey and Letitia James. We also had Rachel Moran of this faculty, who's been a public defender, and we had a great discussion with the students about the duties and obligations of integrity to the law of prosecutors and criminal defense attorneys. I didn't get Judge Provenzino to commit to anything about how she would exercise her judicial behavior. She kept her hat plainly in the capacity of being a former prosecutor. But the questions we posed were this, is like, can the President of the United States use the criminal law enforcement power explicitly to target enemies, personal enemies, for reasons of vengeance and vindication of his personal desires? Can he use the federal prosecution power and the pardon power explicitly to punish people whose views or whose actions he disagrees with? And I think you will see this becoming a huge issue in the upcoming weeks and months in these prosecutions under the rubric of selective prosecution and vindictive prosecution. It is notoriously difficult to get a criminal indictment dismissed as having been the result of a vindictive prosecution. But here there is extraordinary evidence that Trump directed his Justice Department people to single out and prosecute people for crimes because of their views, because of the viewpoints they were engaged in. Just a week or two ago, one of the persons I'll talk about briefly in terms of, in connection with the immigration power, Mr. Abregno Garcia, was indicted for crimes he allegedly committed, and it seems plain that the administration was targeting him not because of his alleged criminal activity, but in order to retaliate against him for his contesting what the administration had done. In all of these areas, I think Trump has engaged in activity that is actually completely outrageous. It may be the most improper thing he has done is to shamefully target people for criminal prosecution because of their views and not for the crimes that they allegedly committed. I'm going to skip immigration for now because we actually did that in the course because we were finding we needed to learn a little bit about First Amendment law. And so just last week or week before last, we did a rapid fire session on the meaning of the First Amendment, freedom of speech. This is its own law school course, and I will try to give you the essence of the law of the First Amendment, freedom of speech in 45 seconds. The core principle of the freedom of speech is that government may not punish, prohibit, or penalize individuals based upon the content or viewpoint of their messages. Government may not punish, prohibit, or penalize on the basis of the content of the message being expressed. This applies to speech, and it applies to expressive conduct. Government may punish conduct for reasons that are independent of any expressive message intended by that conduct, but it may not punish conduct because of its expressive content. And the two cases we use as illustrations of this are a case called United States versus O'Brien, which involved burning a draft card as an act of political protest in the 1960s. The court said you can punish the destruction of a draft card, but you may not punish the destruction of a draft card for reasons of suppressing the act of protest that's being engaged in. Okay, and there will be difficult questions of fact whether that applies in one situation or not. The other case that we look at is one of the flag burning cases, a case called United States, Texas versus Johnson. Texas versus Johnson involved a prohibition on flag burning where engaged in for expressive purposes. It prohibited, Texas statute prohibited the burning or destruction of a venerated object. What these two cases yield is the principle that government may not punish speech or expressive conduct for reasons of its message. And that has broad application to many things that the Trump administration is doing, and we will talk about them this week, Wednesday, and don't tell my students, so some of them are here. I haven't read all the materials for Wednesday's class, but I have about 36 hours. We'll address the questions of Trump's targeting universities for their views and expression. We will address questions of targeting law firms because of whom they have represented and the views they have espoused and whom they have hired as partners. The University of St. Thomas Law Journal will be holding a symposium on November 14th entitled The Constitutional Rights of Lawyers and Law Firms. Put that on your calendar. You can get like 6 hours worth of CLEs and a lot of free food. The next series of issues that we will address after discussing the myriad problems of the Trump administration's attempted suppression of views they don't favor are the questions surrounding immigration. And I don't know the first thing about immigration law, or didn't until I started trying to learn it as quickly as I could in order to teach this class. But there are a wealth of issues, you've probably heard a lot of them in the news, about the immigration power. Trump has purported to eliminate constitutional birthright citizenship. The first sentence of 14th Amendment says, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. All persons born or naturalized in the United States are citizens of the United States unless they are not subject to the jurisdiction of the United States. And it is clear as a matter of history, that not subject to the jurisdiction of the United States means you were the child of diplomats, or you were a member of an Indian nation that was not taxed and not part of the US legal community, or that you were a child born as a result of an act of an invading army. Right? Trump has taken this and said, you are not a US citizen by birth if you were the child of illegal immigrants, persons who were not here lawfully, are not entitled to have their children become US citizens. If I were a betting man, and I am, I would wager that the Supreme Court would decisively reject that view. Other immigration issues concern quintessentially denials of due process of law. It is clear that the United States can limit immigration. It does not have to have an open border policy. It can make it a crime to cross into the United States illegally, and it can make illegal immigrants subject to deportation. I think that much must be conceded. The problem is, they are still persons who have a right to due process of law. The Supreme Court has held that many, many times, and it is clear that the Trump administration's actions have been attempting to deny due process of law by denying hearings, by denying notice, by rounding up people, trying to spirit them onto airplanes in the middle of the night over Labor Day weekend, and put them in El Salvadoran jungle prisoners without recourse. One of those individuals was a man whose name I mentioned, Abregno Garcia, who was sent away by mistake. The lawyer for the Justice Department actually conceded that Abregno Garcia was legally entitled to remain in the United States because of a special immigration status that would withhold him from being deported, but he was deported anyway, and then Trump defied the orders of district courts saying that you had to bring him home. Eventually, they did succeed in getting the administration to comply with that order, but the immigration area has been one where Trump administration has been notorious in refusing to comply with the actions and decisions of courts. I have 6 minutes left and 6 more classes to cover. Let me do them briefly. The next wave of issues that we haven't gotten to yet are issues of war and military power. And these are becoming huge. After September 11th, I invented at University of Minnesota Law School, where I was then teaching. It was before St. Thomas had come into existence, so I can be forgiven for working for the crosstown rivals. I invented a course on the Constitution and war and national security because people right after September 11th wanted to learn about it. You know, as a student, you want to be able to do something, and what we could do is teach and learn. Since then, over the course of 24 years, I've developed a mini expertise of sorts, if writing law review articles can serve as a pretension of expertise, on the issues of war powers. The long and short of it is that Congress has the power to declare war, and the president doesn't. Congress has the power to take the nation from a condition of peace to a condition of war. Congress can authorize war, and the president cannot initiate hostilities against an enemy nation or power on his own authority. Nothing is more clear from the history and the text and the original meaning of the Constitution. In the Constitutional Convention debates, they were reviewing a proposal to change the words of the Constitution from Congress having the power to make war to Congress shall have the power to declare war. And the explanation that they gave, and that everyone seemed to accept, was that Congress could not control the execution of war, and in addition, they wanted to leave in the president the traditional power to repel sudden attacks. Okay? But it is clear from all the discussion that the power of Congress to declare war was an exclusive legislative prerogative to go to war or not. As everybody knows, the conduct of presidents has not been consistent with the Constitution in this regard, right? Practice under war powers has not matched the meaning of the Constitution, and that presents a perennial issue of constitutional law. What do you do when the Constitution says one thing and practice or precedent says something else entirely? I submit that when practice and the Constitution conflict, you must go with the Constitution every time, on the theory that practice in violation of the Constitution does not change the meaning of the Constitution. So we will be studying week after next, or week after next, the attacks on Iran's nuclear facilities this summer, the attacks on alleged Venezuelan drug runners, which are clearly not within the war power and clearly not war and clearly not authorized by Congress. And then finally, we will be learning about the use of military for civilian law enforcement. This is an issue that is pending right now. Illinois' brief is due at 5 o'clock today Eastern Time in the Supreme Court on the question of whether Trump can nationalize the National Guard of Illinois and send the National Guard of Texas into Illinois for basic law enforcement purposes. The Posse Comitatus Act is a statute of Congress passed at the end of the Civil War and Reconstruction, generally prohibiting the military from engaging in law enforcement, but it contains a huge exception, and that is something called the Insurrection Act, which actually is broadly worded enough to permit the president to use the military for law enforcement purposes practically any time he deems it necessary. This is going to be a huge issue, and I fear that the result of it is that the Supreme Court will end up upholding Trump's power to use the National Guard for law enforcement purposes. Well, I promised I would quit on time. I'm going to quit 1 minute early, and you've earned your CLE credit. I hope I haven't tormented you too much, but thank you very much for your interest and for your support and for being mentors at University of St. Thomas. Thank you.
Thank you again, Professor Paulsen, for sharing your insight and your expertise. Thank you all for being here today. Thank you for celebrating Judy, for supporting our students, and for embodying the spirit of mentorship that makes St. Thomas Law such a special community. Have a great rest of your day.